Hello, everybody. This is John Katz at Beat the Prosecution. I'm a criminal defense and DUI defense lawyer here in Fairfax, Northern Virginia. I am delighted to have both my guests here today. I'm going to switch the view because I'm only seeing one of our guests and not me. Okay, I'm going to put this on the gallery. I am delighted. So we're on the gallery after all. I am delighted to have these two folks here, my guests, Michael Bruckheim and Sweta Patel. These are two lawyers who I respect very much. They have a law firm they'll tell you the address in DC and Maryland. I love referring cases to them. They've referred many cases to me here in Virginia. Um, I'll let them both introduce themselves. You choose who's going to introduce yourselves first.
Ladies first, I guess, Mike.
Ladies first.
Mike's a gentleman, and a big advocate of women. So I am a Floridian. I grew up there for 30 years. I moved to the District of Columbia back in 2013. Fresh out of law school. I was 3 years in. I had worked at the public defender's office in Tampa, Florida. Love the experience, got a lot of great litigation behind my belt. Moved up here, worked for another mid-sized firm, Price Benowitz, for a hot minute, about 2 years. And then I partnered with this guy. I somehow
Well, let's
convinced him.
interrupt now. I mean, this is a chance for both of you. I thought you were going to introduce yourselves as law partners first and move backwards. Tell everyone your URL, toot your horn. And now I
So
realize I don't have to have the Brady Bunch camera because I see that green button on top. That tells us who's showing on camera.
There's no one better at marketing Bruckheim and Patel, or specifically Michael Bruckheim, than Sweta Patel. So again,
so I met this guy actually back in 2015, and we
ish, a little before we met before. We met before 2015.
2013, we
Yeah,
partnered in 2015.
yeah.
And Mike was always a great he started off as kind of like my mentor, right? And then eventually, sometimes now I feel like I'm his mentor. But
Accurate.
it was great, and we decided to combine what we excelled at. I have a business background. Mike had the legal background of being a prosecutor in the district for years, and I was developing my litigation skills still in the District of Columbia, trying to transfer some of the skills from Florida that I had, and it worked out. Luckily, we had some trust and luck on our side, and it's been going well 10 years later. We both have a DC practice and a Maryland practice, which currently we're doing a little bit more District of Columbia. Um, but it's challenging. But I guess, the easiest part of the job is working with Mike.
And what is the name of your law firm and what is your web address?
Oh, it's Bruckheim and Patel. And our email, well, www.brooklaw, BRUCKLAW.com. And we are located at 1100 H Street Northwest in the District of Columbia, Suite 830. And
Okay, so the two of you practice in both DC and Maryland, right?
so I mostly practice in the District of Columbia, but Mike does do both, and he's used to do a little bit more Maryland, but now it's becoming more predominantly DC as well for him.
And what are
I
your
had a heavier caseload in Maryland in the past. I don't at the moment, largely because of the fact that I have a heavy caseload now in DC, and also I'm doing a lot more homicide cases in DC, which take up more time. And it's difficult. It's difficult to do scheduling for cases in Maryland and in Maryland counties. So I haven't really taken on any new cases for fear that I'd be spending more time trying to continue cases to work around my schedule than I would just going in there and being able to do everything I need to do for the client.
and what cases are both of you doing beyond criminal and DWI?
We're doing everything from DUIs and traffic related cases, which tend to be a large chunk of our private practice, but all the way to gun possession. Mike's been doing a couple of murder cases, which have definitely kept him in trial for weeks and weeks. And we do everything from violent felonies, and we also do some sex abuse charges. I say some with the caveat that I usually try not to accept cases where there's a child victim. I have a lot of respect for attorneys that can do it, but that's just something that I kind of steer away from in my practice.
Sweta
So
also
who,
takes a lot of family law cases. I will take civil litigation cases, plaintiffs, civil litigation, here and there. I have to be kind of super selective with those types of cases again for the same reasons that I don't do a lot of work in Maryland, which is just my trial schedule in DC.
Mike, you may be the first former prosecutor here on the show, and I really have a lot of questions. I'm not going to do this to the disregard of Sweta, but where did you go to law school, and when did you graduate, and when did you go to the dark side?
I went to law school at the Washington College of Law at American University. I graduated in 1996. I went to the dark side the way I think many other dark Jedi Knights are tempted. At the time, they didn't really have kind of much going on. I had a couple of jobs here and there, none of which really amounted to much. But I really feel like my career got started when I went to the dark side. In 1998, I believe I started working for the DC Office of the Attorney General, although at the time they had the far less sexy name of the Office of Corporation Counsel.
Okay, I'm going to be fair to you now. I remember the great Tony Serra, who was on my show last year. For a short time, he was a prosecutor, and I didn't give him a hard time. So about that. So maybe I shouldn't give you any harder a time
Or you can
than
make up
that.
for it now that you got me here.
But by the same token, I never had any cases against him. By the time he finished prosecuting for a year or two, I probably hadn't even finished college yet. Now, did you and I have any cases directly against each other? Were you a supervisor by then?
I don't think we had any cases directly. I When I started there, I was the equivalent of a line prosecutor from 98 until 2001. And then I went to different divisions within the office. I did civil litigation defense for a couple years. I was with the DC Office of Human Rights. I went back to civil litigation. But towards the end of that decade, around '07, '08, maybe a little later, maybe '08, '09. So I'll kind of blend it together. But I returned to that section of the criminal section as a supervisor, and I was there for about a year. And I don't think we had any direct cases. What I remember of John is all the line attorneys complaining about John because he was aggressively litigating every DUI defense case he had and filing motions and discovery requests and discovering demands, and they just could not stand him,
A
which I
million
think is
for
the highest
defense,
compliment I can
not
pay
a
you.
penny in tribute.
Yeah, there are few line attorneys, I think, who would say they were fans of John Katz because of how he litigated the cases. Nothing to do with personality or anything like that, but he gave them a lot of work.
You know, that reminds me what a cop said to me one day. I don't know if I mentioned this previously on this show. When I won a DWI case in a county of Virginia, which I won't name for a reason I didn't understand, the judge said, "Well, I'm not convinced that the defendant didn't drink from this unsealed container of alcohol that the police officer said he saw on the passenger seat." After the cops stopped him. We don't see anything in the dash cam showing anything consistent with doing that, that the judge found him not guilty on that. And as I'm leaving the courtroom, I hear these footsteps come after me, boom, boom, boom. And the cop says to me, "I want to shake your hand. That's the best performance I've ever seen in court." He said, "I don't like what you said about me, but it was still a great performance."
That's great and that's interesting. And I think a lot of cops, and I would say a lot of cops who practice in DUI defense sort of know the attorneys who they see on the regular. And, I think they have respect for attorneys who will put up the fight. And I had one cop tell me, he said, "Look, we have, it's like a bunch of us, we got a lot of respect for you and we keep your name on file. And he said, because we're cops, we do a lot of crazy shit. And if we get arrested, we might call you. And I've gotten referrals. I've had officers, call me for like family, friends, sometimes, for themselves or in different counties if things happen. So I mean, I don't think there's a higher compliment than to get a call or a referral from a police officer or from a prosecutor, and I've had that. Sweat and I both had that happen a couple times.
Well, one of the coolest referrals I got from a police officer was for his son. And a year or two before, I'd gotten an acquittal with him. And in another instance, I'll try to avoid identifying anybody. A prosecutor did refer me to a cop, and the cop said to me, or maybe to a cop who's looking for someone for his relative, and he said the prosecutor said he doesn't like dealing with me in court. Now, we're not going to have Michael only on here. Okay, Sweta. You mentioned Price Benowitz. All right, well, I assume that was a rather secure job. What made you leave there?
I think it's a lot of reasons why many attorneys leave firms. They're great people to work with, and I've had some very good experiences with Dave and Seth over there. But I think it's just a matter of upward growth, right? So it was just trying to find more opportunities. Sometimes when you are in a mid-sized firm, there tends to be harder times moving up the ladder, quote unquote, because there, for various reasons, might be other attorneys that are more senior that are already there. There's less space to move upwards in a smaller practice. So I knew that the attorney that was there before me was unfortunately a very good attorney. And I knew that he had 5 years in me at the firm. And I knew that it'd be really hard to get ahead of that because he was good. I guess if he wasn't good, it'd be a different story. But so when I decided to move to Mike, it was more of a opportunity for me to grow as an attorney, be able to have a little bit more independence. But also, I've always been drawn to business. My family grew up in the hotel business. I have a business background. I went to school for business. I think if I didn't become a lawyer, I'd go to MBA school. And so it was something that I always enjoyed doing. And I think it also gave me a lot of, at least partnering with Mike, he gave me a lot of flexibility, a lot of leeway on how I wanted to approach the growth and how I wanted to market. So it was kind of exciting. And I was only 30 years old at the time, right? So it was, for me, it was an opportunity for professional growth, and I took it. I think if I would have stayed at Price Benowitz, it's not to say I wouldn't have professional growth, but perhaps it would have come at a much slower pace for me based on just who was there, how many spaces are available, and just the realities of working in any firm.
So both of you took that plunge like I did in 1995 at the age of 32 to give up the security of a paycheck to be our own bosses. So did you have any specific plans, Sweta, to make sure that it would work?
I mean, I think I was praying and really hoping that my father would take me back in if I failed. That was my backup plan. So, but no, I mean, I think I had prepped in advance before I did it. I had, I'm a planner. So I had started planning 6 months prior to me deciding to take the leap. I had kind of started saving and making sure that I could, last the lower months of still trying to build up my caseload at another practice. But that being said, I think that it helped because Mike already had an established practice of his own and his reputation. And so I didn't come in with just nothing. I was helping him expand on business that he already had. So it was a little bit easier than I would say building from the ground up, where you're kind of, I was fresh in DC and, we didn't know each other back then, but I didn't know a lot of attorneys yet, right? And that was one thing I knew Mike had going for him. And I think that really helped us is that he had this referral base. He had this reputation of being a great DUI attorney. He had connections for years that I didn't have just based on him being stationed here. Now I can say I have connections and like, I know you. And but back then I really capitalized on Mike's assets. And I think Mike said it like what I was good at was marketing Mike. And I marketed him better than himself. And I still believe I can do that better than himself because Mike can be humble. Sometimes he can not be humble, but most of the times when I need him not to be humble, he's humble. So
I'm going to jump in here and tell a little positive vignette about Mike. One day when I was still living in Maryland, I think he and I both bumped into each other at the metro station to go downtown to work. And I drove Mike, or Mike drove me down there when the metro wasn't working. And I said to myself, okay, uh, he was on the dark side, but I think he's cleansed himself by now if he had anything to cleanse himself about. Mike, you remember that day? That was so many years ago.
I do, yeah. If we from the Rockville Metro station, and it was just one of those off days on the Red Line, and we cruised down there, and by then I was carrying a green lightsaber blade. I'd abandoned the red blade that I carried for so long, so yeah, so it worked out.
Well, that was over 12 years ago because I relocated to Virginia 12 years
It
ago.
doesn't seem that long ago, but but yeah.
Well, Mike, when you went out on your own, that was without Sweat to promote you. So did you have a business plan, and is that what you ended up following?
Yeah, so I went out on my own in 2010. So I had left the office of the Attorney General to actually go work at a firm, at a mid-sized firm, and it turned out to be just not a good fit. I was miserable, quite frankly. I don't think they liked me too much. I only lasted there for maybe 2.5 months. And I remember leaving on that day, and instead of feeling worried or upset or mad, I felt relief, like it was a new beginning. And I realized I was at the point in my career where I couldn't have a boss anymore. I could work with people, deal with people, but I was done having supervisors or asking permission to do things. And so I knew I had to go out on my own. And then the question was, well, what should I do? And the best contacts I had at the time were the contacts that I had made when I was working at the Attorney General's office. When I was chief of the section, I knew, a couple judges. I knew that I could apply to get onto the Criminal Justice Act panel or the CJA panel. And that's basically a cadre of attorneys who operate in DC Superior Court who get appointed to criminal cases that can run, the spectrum from traffic cases to very serious cases. And you get appointed to the case and you work the case and you submit a voucher or your bill, and the bill gets paid by the government finance office. So it's a nice, steady way to earn and do trial work and practice criminal defense if that is your interest. So I knew I had to get on the panel, which I applied to do almost right away. And then in the meantime, I figured the best specialty for me was DUI defense because I at least had a perspective about it from being a prosecutor specializing in DUI prosecutions. And so my business plan was to get as much training as possible, as soon as possible, obtain a reasonably priced office, and get a website up so that people could find me and see who I was, and then just sort of kind of put the word out through a lot of the defense attorneys who I knew at the time that I was kind of entering the game, and that's what I did.
I entered towards the panel in two interesting ways. First, around 1991, which is when I moved over to the Maryland Public Defender's Office after being with a corporate law firm for 2 years doing civil litigation regulatory work. I actually did that one day of training to do the CGA court appointed work. And Samuel Delgado, who's a great lawyer, he was a
Hmm.
public defender lawyer at the time, and he I think he gave one scenario. He said, look, he said, I'm going to talk to you about doing bonds. And he said one day he had to show up on this crime scene, and his client had been arrested for raping a corpse. Well, what are
Ugh, boy.
and he said that is the real test about whether you're able to work as a criminal defense lawyer. But beyond that, I mean, he was so animated in talking about how with bonds, if there's a question about where the defendant works, you just say right out, he doesn't have a job, just be straight out for that. But I didn't even have to do consider the panel until uh, 7 years later when I went into private practice with my former law partner, Jay Marks. And the only court appointed work I ever ended up doing there was during the 2000, they called them the A16 demonstrations. You may remember that, the
Yep.
demonstrators against globalization, against the World Bank and the IMF. And I didn't really
I
have
was prosecuting in court when,
oh,
yeah, we were
okay.
on sort of like this extended duty, and I remember being in the courtroom, and they were bringing everybody in, and everyone was asking for trials, and a lot of the arrestees, the people they brought in there, were very animated, and yeah, they brought a lot of cases, or at least filed a lot of cases against them, and then we ended up dismissing them a couple months later.
Well, let's talk about that then, because I got involved with that because the succession was in late 1999. Ramsey Clark and I got hired to represent Phil Berrigan and Elizabeth Walls and Susan Crane and Father Steve Kelly after they were hammering on warplanes against the depleted uranium that they fired. And I wanted more understanding about how to defend these demonstrators who get arrested and admit what they did often. And so someone suggested contacting Mark Goldstone, who, of course, who's been on the show before, who does a lot of the
Yep. Still
protesters
still
work.
does. Yeah, he's an
And,
icon doing that type of work.
and I got involved with the National Lawyers Guild, which always has been too lefty for me, but still they represent a lot of civil liberties causes. And it was through the National Lawyers Guild that they were assembling a bunch of the court appointed lawyers for these protesters. And that's how I got involved with that. And so I ask you, how did you feel about being on that side of the prosecution for those cases?
I didn't feel great, to be perfectly honest. A lot of the folks were there, they were protesting their cause. I know a lot of people were upset because of different shutdowns in the city that resulted from the size of the protests. I don't think anyone in my office at the time was really equipped to figure out a plan for protest cases. And what I mean by plan is not thinking just one or two steps ahead, like, okay, well, we'll file this charge because they crossed a police line, and we'll go to court and we'll see if they want to post and forfeit $25 to end the case. But they weren't thinking several steps ahead, which is, these people were exercising their rights to protest for a cause that they believed in, that they weren't, going to submit to any type of government suggestion or authority. And if you have hundreds of arrestees who are all demanding trials for admittedly minor conduct in the grand scheme of things, what are you going to do? And they weren't thinking about it then. And then they ended up dismissing all the cases, which quite honestly, myself included, made a lot of line prosecutors feel like, well, why did I give up like my weekend, just to go there and, do this work and be there if at the end of the day you're just going to drop the case? Like, why don't you just drop the case or not file a charge or release them? So it's that was really kind of like my first exposure to that. When I was in the civil division, I was on the defense side where lawsuits had been filed against DC and different police officers as a result of different protests in the early 2000s. So I got to see, I guess that culture early on. And I remembered it, and it sort of helped in a few civil cases that our office has had. We've worked with Carl Messinio and Mara Verheyden Hilliard at the Partnership for Civil Justice,
Right.
and in bringing cases against the District of Columbia. I'm working with them now on one case. We had another case where they were working with us, but we ended up settling last year. And the funny thing, and I always kind of joke about this with with Carl is he was the lead plaintiff's attorney in those protest cases that for a period of time I was helping to defend in terms of representing the District of Columbia. And I remember him being super aggressive. I always joked with him like how I couldn't stand him at deposition. And we ended up becoming pretty good friends a few years after that. Carl, for a period of time, was practicing criminal defense, and so I worked with him. We tried a armed robbery case together, and we stayed friends after that. He's probably the first person I would call if I had a client or someone who wanted to sue a governmental agency in the District of Columbia.
Okay, well, Sweta, I'm going to ask you the question that I could also ask Mike. Have you been in that lockup in the DC Superior Court, and is it still the same hellhole it's been for decades?
So I have recently, at least for the last since COVID, there's been this great thing called stand-in attorneys, especially for C10 lockup. So it's really assisted with some of the court-appointed cases that we sometimes get where there's a stand-in attorney that covers the initial release hearing and will send you all the information. However, for a lot of our private clients, they may still want to go to C10. It's still, the wait's just been getting longer and longer. It's turned from 5 o'clock to 6 o'clock to, we've heard stories of attorneys being there till midnight. Because of all the charges that are coming through lockup, they're papering everything. And then they'll decide if they're going to drop something later on, whether they have a case or not. And so it's really unfortunate because it really jams up the system for several reasons. One, it doesn't focus on the worst crimes that DC has, which is the violent felonies. Now you're handling the guy that is peeing on the street corner who's not hurting anyone, or someone that may have a small amount of a possession kind of charge of some kind of narcotics versus someone that may have, you know, a gun that's illegal. They're focusing on individuals that are lawfully detained and or lawfully have licenses in Virginia and Maryland and maybe made a mistake about coming into DC. So I think the focus of a lot of these arrests, the uptick, has really resulted in ultimately losing focus on what I think citizens care about more, which is the violent felonies and the ones that are a harm to society versus individuals that are perhaps made a mistake or are just in the wrong place at the wrong time. Now everybody is being arrested. Uh, the the thought of are they guilty or innocent is second. Whether if they have a way to charge, they are charging. And discretion is unfortunately not in the prosecutor's hands for the most part anymore. It's all made higher up with the supervisors. So it's really changed a lot of the optics of just practicing in the district. And I think it's made the quote unquote hellhole and C10 even worse the last 6 months. Particularly, I think the judges' hands are tied when the government asks for a hold on everything. I mean, I kid you not, I had a client recently that was no priors, licensed to carry a firearm in Maryland and Virginia in the district, but it had just expired inadvertently, didn't realize it, registered in DC, but everybody believed him, but they didn't care. They charged him. But not only that, at C10, they asked for a 3-day hold on this guy. And the judge couldn't do anything. The judge had to grant it because of the hold that they requested. And 3 days later, the judge basically, in preliminary hearing courtrooms was just like, all right, just call in once a month. This poor guy had to go through 3 days in lockup. He's never been through the system ever. And for something that was an administrative perhaps misjudgment in the date and was trying to do everything the right way. And so a lot of cases like that are going through the system now, where in the past, the government would not have asked for a hold for someone like that.
All right, I'm going to
Maybe.
expand that question, Sweta, to the physical hellhole of the lockup in Superior Courts building, if it still is, because I haven't been to that lockup in years. The hellhole of the DC jail, which still is a hellhole.
Oh,
I've been there. I was there only about a year ago for the last time, and I wonder why that doesn't at least convince many more people to watch what they do to not be there, because even federal defendants end up getting held there, as I understand,
Yeah.
together with what just totally aggravates and irritates me, although I don't do a lot of DC cases anymore, is this attitude that I get from so many of the people working at the courthouse, at least with pretrial services. Yeah, fine. If you have to be urine tested regularly, what's the civil liberties problem about that? And just processing people through, and even with probation aides, just process people through, never questioning the wisdom of the system, never questioning the wisdom of the sentencing that happens, or the sentencing system, or of the law. That's a biggie there, but at least take your pick or answer all of them.
Yeah, well, I can start with the jail. It's just as bad as you envisioned, just worse now. Now it's longer wait times. It's harder, lockdown all the time. Um, Not enough space. I mean, the list just got worse, I guess, from the last from the year that you went. You have to make sure you account for plenty of time to go visit your clients. It's really hard for clients to get discovery. It's not as easy as even just calling your client. That's not allowed, in the district. Unlike Virginia, you can call your client. Here you can't. So there's a lot of issues there, but I think more what I would like to focus on out of the couple of things that you mentioned was probation, which I think does affect a lot of Virginia practitioners, Maryland practitioners, and DC practitioners, especially because we have clients that come into DC, work in DC, live in DC. We have so many complex issues, and we've come into that multiple times, particularly with our DUI clients. Um, Sometimes CSOSA acts like they're in charge of the judges.
CISOs is the probation office, right?
Correct. And I've seen the judges even get mad. There's two theories. We have judges that essentially get kind of mad when the CSOSA tells them they can't do something, but CSOSA acts like they have authority over the judges. And then we have the other category of judges that kind of give CSOSA credence to the point where they are God, and the judges believe whatever they CSOSA says is correct and it doesn't matter. And they default to whatever CSOSA wants. And those are kind of like the two types of judges that we typically have in the district. I will say the felony judges tend to push back a little bit more, but there's still a little bit of credence given to them. What I see it often is, I guess the benefit of the CSOSA and DC is that judges don't impose fees for supervision. So that is a reason that often you may want to keep probation in the district because, for example, if you transfer DUI probation to Maryland, your client's going to be hit with supervision fees and drug testing fees and all these fees that are not, given by CSOSA in the district. That being said, they make it very, very difficult to get transferred to another jurisdiction. We had a client recently, maybe a few months ago, where we wanted his probation to stay in the district. And CSOSA fought us so hard. It's the only time in my entire life where the prosecutor was fighting with me and the judge was fighting with me. I
Right.
was like, it was almost like the judge, the prosecutor, and the defense attorney were all on one side, and CSOSA was against all of us. And at some point, the judge just got over it and just changed the entire sentence to benefit my client. But it was just like, CSOSA wasn't even allowing the judge. And the judge was like, so you're saying I have a case in my jurisdiction, in my courtroom, and I can't tell you to keep it here? And CSOSA's response was no. You can't
Now,
make keep it here.
the name of this show is Beat the Prosecution. We're going to get that after I ask Mike this question. So, Mike, you're doing murder cases, and are these all in DC? Or any of them retained? And if you're doing those, that means you're dealing with the U.S. Attorney's Office. So, for that and the other cases you're dealing with the U.S. Attorney's Office, how have things changed there with this current Trump administration, including with Jeanine Pirro being at the helm of the U.S. Attorney's Office in D.C.?
All of my homicide cases have been in DC. None of them are retained. They're all court appointed. I think getting a retained homicide case in DC is a rarity because the fees that one would have to charge are pretty extensive. So there may be some people who could afford a retained attorney. The clients that I've had have all been court appointed. How has the U.S. Attorney's Office been? The prosecutors who I've dealt with in those cases, I can honestly say have been fair. They've been upfront. I haven't always agreed with arguments they might make, legal arguments they might make, but I would always know, what was coming. Um, I think the sting or the bad effect from the well, one of the many bad effects of the Trump administration, and particularly uh, Jeanine Pirro, is that their methodology, their logic in terms of what makes, you know, you have to ask, like, what makes a good prosecutor, number one, and then also, what do prosecutors fear? Prosecutors fear losing their jobs and they fear making a bad call. They fear not making a fight, perhaps on one defendant, and saying, you know what, this defendant doesn't have a record. We're not going to ask for a hold. And then down the road, while that defendant is on release, that defendant commits a violent crime. And those are always the things that we hear about in the news. And then everybody, particularly on the Republican side of the aisle, is like, DC's soft on crime, DC's soft on crime, where that's absolutely not the case. A judge making a release decision to release someone who's charged with a gun offense who doesn't have a record is basically following the law that is in place and analyzing all the factors that they should analyze. And the problem with this current administration and it's the same, but we've seen a lot of times in different prosecutorial offices. Whenever you have somebody new comes in there, their first attitude is, we're going to arrest everybody. We're going to charge everybody. Everybody's going to get charged. We're going to be hard on crime, tough on crime. And it might sound good for a soundbite, but it doesn't get to sort of the root causes of why a lot of these people are there. Now, certainly, you would expect them to be tough on violent offenders or repeat offenders, and that's fine. But like Sweto was talking about, to basically paper every case, like every little rinky-dink misdemeanor charge, that comes through, you can spend more of your focus trying to get people help. Because a lot of people who get arrested for these types of offenses, it's not because, they're a bad seed or anything like that, but it's because they've been in difficult circumstances in their life where they haven't had resources available to them to help them, either whether it's with mental health or with its housing or with its any kind of addiction. And, this administration doesn't care about that, unless you're wealthy and white. But otherwise, their attitude is all these people, need to get out of here. Like their attitude towards unhoused, towards homeless. They're like, we're going to get homeless people out of here, as if being unhoused somehow equates to someone who is more likely to commit a crime, when you have people who, lost a residence and maybe, and quite possibly through no fault of their own, but perhaps through the the mortgage industry that's basically running people out, that caters to, oh, what a surprise, rich white Republicans, who form, the MAGA base. And, these people get tread on. It's sort of like, this party treads on certain types of people, makes it impossible for them to kind of just get forward in life and just earn and do what they need to do. And then if they get arrested for something, then they just get blamed for being in that situation. What's the old white man Republican response to somebody who's unhoused and unemployed? Well, pull yourself up. Have that fighting spirit. Go get a job. Go get out there. And it's like, get a job. It's not that easy to get a job. It's not that easy to get a job even now. Like if you have like a traffic ticket. Everyone does background checks. Nobody wants to see anything. I mean, pretty much the only job you can get if you have multiple felonies on your record, apparently, is the presidency. So other than that, it's difficult. And the current administration does nothing to take that into account or to find ways to not just, prosecute. Sure, they can prosecute as many as they want. It's easy to do, but also to work with them to ease off on the arrests. They got these cowboy police officers out there is just arresting anybody for looking at them cross-eyed. And that's not, the society that people want to live in. Go solve, if there's unsolved homicides, by all means, go do it. Do your thing. Arrest, find people, arrest them for the serious violent felonies, and then we'll see what evidence you were able to come up with, and see what we can do on that. So that's kind of my somewhat long-winded take on that entire situation. So to sum it up, the attorneys who I have dealt with thus far, who have represented the government in the homicide cases I haven't really had any issues with. Have I heard stories or prosecutors sort of being, a little tricky with evidence? Sure, they're all out there, but I cannot say that I have had that issue in any of my cases. It's just been straight up. They put on their evidence. I fight, I fight against it. We argue against it. We clash. We battle, and that's how it goes. And that's probably how it should go.
Yes. Sweta, how often do you go to trial? And what are your two or three favorite ways to beat the prosecution? Knowing that prosecutors are listening, so you may not want to give up all your secrets.
Yeah, I mean, I think it's always a balancing act on how much to reveal pre-trial and what strategy you have. I think there are times where I disclose more if I think it's going to result in a favorable resolution for my client that I otherwise wouldn't get. I'm a big fan of mitigation packages, especially for clients where I have a lot to say, and I found that works really well pre-trial. With during trial, I think it's like a whole nother game, right? It's been a while since I've been in a felony trial. I think the last case I was in were motion hearings. And so they ended up being stipulated trials either, or the motion being granted, one or the other. And so we never really got to the trial phase of that. For better or for worse, I guess it's great when your motion is granted, but a lot of times, what we've seen is when you file really good motions, it ultimately results in sometimes a better offer for your client. I've gotten felony cases where closer to the motion date, the prosecutors offered me misdemeanor offers or, really good offers that my client just can't walk away from when they're facing 5-year minimum mandatories, right? But I think it's a balancing act, right? You need the evidence that you need, so you do have to disclose certain things and why you're requesting it sometimes. But I think that especially with stop issues, I like to not give away my entire argument in the motion to suppress. I like to hold back on some of the argument. I may cite the case, but I won't dwell too much into it so the prosecutor doesn't look at that argument. But I've cited the motion, so I've cited the case, so I can still refer to it in my arguments. So there's little strategies like that I like to employ, especially in the motion stage. As far as, trial, I think my MO is always, Mike and I have different but similar cross-examination techniques. I tend to have the witnesses tend to think that I'm unalarming, so they tend to be nicer to me and they tend to give me the information at the beginning. And so I try to really get them buttered up and on my side. And I try to make sure that they don't see me as threatening at first. And I find that they're a lot more cooperative. And a lot of times, it's worked several times for me, is that the witness doesn't realize that I've gotten them into a situation where they unfortunately have to give me a response that's not, that they realized it too late, especially when it works with officers a lot. I like using that strategy a lot. I say use sugar until you have to use vinegar.
Right?
That tends to be my strategy. But at the same time, I think sometimes the officers particularly can be very taken off guard when you're nice, 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 and then all of a sudden you just pour vinegar on them.
Right?
And I think that's worked well for me. I think Mike has a little bit of a different strategy when it comes to cross-examination. And I say this like watching Mike do cross-examination, he's extremely likable. Like you just want to believe him. Like,
Well, one of my favorite cross-examination approaches is after the cop has over-exaggerated what's depicted in the incident video, then I maybe ask a few cross-exam questions about, okay, well, this segment of the video I just watched, you already said it's a true and accurate video, right? Including that section. And then I'm able to loop it together in closing and say to the judge, we can't believe anything this officer has said that's not corroborated by the video. For instance, with a DWI case, the officer said heavily slurred speech. We didn't hear it. The cop said stumbled as he got out of the car. We didn't see it. The cop said that he kept taking wide steps in doing the walk and turn test. We didn't see it. The cop said if it's a refusal case, because refusal is an offense here in Virginia to do breath testing or blood testing, if it's a civil refusal case. The officer said, at least in jurisdictions where the video runs, he says that he crystal clear told the defendant, if you don't do the breath or blood testing, these are going to be the consequences. And instead, the cop actually confused the crap out of the defendant to make him unable to do an unreasonable refusal. So with that, Michael, to what percentage of your criminal defense practice is DWI defense, and how many cases do you actually bring to trial for DWI? I understand that in DC there these deferred sentencing agreements and deferred processing agreements are so common that that would reduce the number of DWI cases you bring to trial.
I would say overall, over the course of my entire practice, DUI has probably been about 70, maybe 75% of the cases that I've had. And you are correct. You know, as I sort of hinted at before, prosecutors' offices, they're cyclical. So they go through different phases. And, right around COVID and for maybe a year or two after COVID, the DC Office of the Attorney General was pretty reasonable in terms of offering favorable resolutions. And when I talk to a client in a DUI case, when we're talking about plea offers, I put it very simply. I say a good plea offer takes away the risk of something worse happening if we were to go to trial and lose. So if I have a client who's charged as a first offender with driving under the influence, if the plea offer is plead to driving under the influence, we're going to reject that always out of hand. Because, and I think another great DUI attorney who we know and who we're friends with, Lenny Stam, who practices in Maryland, said if you plead guilty, you have a 0% chance of winning. If you go to trial, your percent chance of winning increases over 0. So, and of course, it makes sense to go to trial, in those situations, unless the government gives you a reason not to. A reason not to was, as you stated, is for some type of diversion agreement, a deferred sentencing agreement, a deferred prosecution agreement. Recently, the government actually has been more strict in terms of offering those types of diversion agreements. I haven't seen a lot of deferred prosecution agreements. And for the listeners, a deferred prosecution agreement is where the government says, we're just not going to prosecute your case for a while. We're going to put it on a shelf. Go do some programs or some community service. Don't get arrested for anything. You come back in a couple months. If we're good, we're just going to drop the case. A deferred sentencing agreement is a case where the government says, plead guilty to a charge. Usually it's driving under the influence. But under DC law, it is not a conviction because under DC law, you're not convicted until you're sentenced. So what we'll do is we'll just continue the sentencing date for a period of time. And then during that time, again, if you do a bunch of things, a bunch of good things successfully, then when you come back on the sentencing date, you can withdraw your plea and we'll dismiss the case. But if you don't do everything, or if you get arrested for a new offense, if you violate the agreement, then when you come back on the sentencing date, you'll be sentenced, and then you'll actually have a conviction on your record. So the attraction to that was, well, it puts the client's fate in the client's own hands. The client knows that a dismissal is guaranteed if a client does what they're supposed to do. And most of the time, those types of agreements are favorable versus going to trial unless you have a number of good issues you can raise. Lately, even doing a deferred sentencing agreement has had some pretty impactful collateral consequences, mostly when it comes to driving privileges. In the District of Columbia, the DC Department of Motor Vehicles, which in my opinion is the most diabolical of government agencies, and that includes the IRS, by the way, they will revoke your privilege to drive even with a deferred sentencing agreement, because they say we consider a conviction to be just a plea of guilty, even though DC law says a conviction is not just a plea of guilty, it's a plea plus sentencing, or a guilty finding plus sentencing. But DC DMV says, you know what, if you plead guilty, we're taking your license away. So if you're licensed to drive in the District of Columbia, then you could be grounded, like not able to drive unless you put ignition interlock in your vehicle. If you're licensed to drive outside of DC, then your ability to drive in DC could still be revoked. And what DC has been doing now is sending letters to outside jurisdictions. So again, most of our clients, if they're not licensed in DC, it's Maryland or Virginia. And we know for a fact they're sending letters to Maryland saying this person was convicted of a DUI. And Maryland says, oh, really? Well, okay, if they're convicted, because Maryland defines conviction differently, if you're convicted, we're going to suspend their license. So then our client has to then request a hearing at the Maryland MVA and go before them and explain actually they haven't been convicted of anything. And that's just with the driving privileges. There's always issues in terms of security clearances, job clearances, immigration consequences. So while a deferred sentencing agreement on its face technically is a better result than just a straight conviction of DUI, in a lot of circumstances, people still get treated like they were convicted of DUI, even though they weren't.
Okay, so let's bring this back to the actual frequency with which you take cases to trial, and also for the DWI case, the extent to which your involvement with the National College of DUI Defense helps you out. I mean, for me, I go into court just, I consider it a big favor for me, for my client, just to plead not guilty. I love going to trial. I mean, there could be exceptions if my client who's caught by 10 eyewitnesses, 100 videos, committing mass murder of 10 people is offered a jaywalking plea for $10. I think I'd have a serious talk with them if they rejected that plea offer. But prosecutors know this, to the point where one prosecutor once said to me when I said, am I irritating you? When I was trying to negotiate a case, he said, nah, you don't irritate me. He said, we just wonder what makes you tick. We wonder how you make any money. It seems like you're working all the time and defending your clients all the time and not sleeping, just the way I like it. So, what's your frequency of taking cases to trial, and how much does your involvement with the NCDD help you out?
The NCDD helps immeasurably with resources, just advice from other attorneys on any number of issues. How often do I take cases for trial? It's better phrased, I think. How often do I set cases for trial? I set cases for trial for DUIs pretty frequently. The most recent ones I had 2 cases set for trial in July. One of them got dismissed just outright before the trial date. The other one, I did go to trial over 4 days, and it was a more difficult case. It was a first offender. Client was charged with DUI, but there was a breath score where I made what I felt like were some good arguments to keep the breath score out. There was a collision. I crossed and argued, best I could on everything. She ultimately was found guilty and pretty much given the same type of result that she would have received if she had just entered a plea of guilty, but we had a lot of issues to raise. The tricky thing with the District of Columbia is first offenders, unlike I think almost any other jurisdiction in the United States, except for maybe, I don't know, one or two states, a first offender charged with DUI in DC does not have a right to a jury trial. So all those trials are bench trials on very crowded calendars where it's pretty difficult to finish a DUI trial in one day. Even though you have to be
Oh,
there at
it's
9:30
crazy.
for the trial call, it may not start until 2 o'clock, and court in DC stops every day at 4:45. So the trial that I just mentioned, we had, I think, four trial dates, and then we actually came back for the verdict. And the other issue is, you're dealing with a jury of one, that being the judge, and it's difficult to get judges to go outside the box on. Over time, over the years, both Sweat and I have made creative arguments, different arguments that we believe we are right and correct, but still, judges, I think, talk amongst themselves. No judge wants to be the first judge to throw out a case based upon sort of like a new theory. Um, and that makes it difficult because again, you'll have to go to trial, you'll have to appeal. And I think one example of that came with the confrontation clause. And this is back in the early 2010s. A lot of this happened actually before Sweat and I even partnered up. But for a period of time, the District of Columbia was using urine testing and not breath tests at all because they had issues with their breath test
Oh yeah,
program
that
because
was
the person
crazy.
running it, right, you remember that, the person running it was basically lying about everything. So they scrapped that, we're reorganizing that. So instead, they went to urine testing where instead of breathing into a tube, you were peeing into a cup. And that had its own set of issues, the biggest one being that urine testing is completely wildly inaccurate, and any so-called expert who the government will call will agree on that. But we made some objections because the district was just calling in their expert, the person who was running the urine testing at the time. And in light of recent case law that was coming out, and particularly the Supreme Court case of Bullcoming versus New Mexico, which said that in a DUI case, if the government is going to introduce a chemical testing result, then they have to bring in the people who actually handled the sample, did the testing themselves, instead of just bringing in an expert to say, hey, yeah, I looked at all of these papers and I looked at everything and it looks good and this is the score. And that was Supreme Court law. And we were jumping up and down arguing that on every case. And the judges, I feel like they kind of banded together and said, well, we're not going to acknowledge this. And they came out with some cockamamie opinion that said that an expert could talk about it. They didn't need all these people coming in. And it wasn't until the DC Court of Appeals in a case called, was it Young versus United States, I believe, issued an opinion related to DNA testing, but said, hey, you got to bring in the people that did the testing because, oh, by the way, it's the law, and the Supreme Court
Right.
points out. So that's kind of an example of sort of like what you have to go through to try to get judges to think differently outside sort of like established practices. And we had the Supreme Court on our side, and they still weren't doing anything until the DC Court of Appeals did something.
Right. Well, right. One approach to beating the prosecution is using the existing case law and moving to change it and doing the appeals. I told you both we'd go till 5 o'clock. We're a little later than that. I only feel fortunate that since both of you are my friends, I can keep talking to you later on about a lot of this stuff. But I want everyone to
Anytime.
know what both you know. There are a small percentage of fellow criminal defense lawyers in the area who I know are true believers who I have so much confidence in that when I refer them a case, I know they're going to do a great job, who I know that if I contact them about a tricky situation, they're going to totally understand what I'm talking about, or at least not make fun of me about it. Hey, why are you taking this case to trial? Isn't that stupid? Why don't you just like save your Friday? And there are lawyers like that who shamelessly will say that to me on a beautiful Friday afternoon. Why are you taking this to trial rather than taking that good plea? No, I'll take it to trial and win. And I really appreciate both of you so much. And I'm not going to make this an online love fest too long. But with that, but it is a love fest towards you nonetheless. Sweta, is there anything you want to tell the audience that you have not already said?
I think we covered a lot of ground, but yeah, if anyone ever needs any help or any practitioners, feel free to give us a call, email us. I think we do better by email, but it's my email is Patel, Patel at Brooklaw, BRUCKLAW.com. And Mike's email is basically the same, except it's Michael at brooklaw.com.
And Michael, is there any final words you wish to say?
Yeah, just thank you so much for having us. Anybody who needs assistance in the District of Columbia can call upon us, me, and Sweta. We have, slightly different ways in how we handle a case, but the one thing where we're similar is we're very aggressive, we're very well known, we're respected, and at least I will say when it comes to DUI cases in DC, the Attorney General's office, they know who I am and they know that I take cases to trial. And I would say that to anybody looking to hire someone, especially you, John, which is you want to hire an attorney who they know will try a case and not just kind of come in on the trial date and say, okay, we're just going to plead to the information. Um, we've referred many, well, really, I would say almost all of our Virginia inquiries that have come our way, have gone to you. And I always say the same thing to everybody, which is I say there's only one person you need to call. It's John Katz. Here's his number. That's it. I got nobody else to say. And I said, if he can help you, he will. And if it's in, I don't know Virginia geography, so he might say it's in some county that I think is next door to you, but it might end up being like 4 hours away. But I'll say, hey, if he can't get there, if he can't travel there, he will know somebody who is like-minded who can help you.
Well, thanks so much. And I feel the same about the two of you. Everyone you have heard from law partners Michael Bruckheim and Sweta Patel in Washington, D.C. at brooklaw.com or brooklaw.com. I guess I've been mispronouncing it all this
You've
time.
been doing great.
This is John Katz at Beat the Prosecution. I'm a criminal defense and DUI defense lawyer in Fairfax, Northern Virginia. There is no other way than beating the prosecution. Thank you so much.